can be introduced in the new law. The makers have, beautifully synchronized it so that technology can help in, creating evidences at the crime scene. Technology can be used by recording statements, because sometimes it happens that the crime scene happens in the year 2020 and the witnesses are recording their statement in the year 26. So is your memory so fresh that you will be able to tell the exact statement or the exact phrasing of sentence? Will that help the other person, the accused, to take benefit of your situation? So if you record that statement, it will be beneficial, because then the conviction rates will increase. It also addresses the issues related to organized crime and mob lynching, as organized crime has been defined in the new law, Bharatiya Sakshya Adhiniyam. Investigation and charge sheet was not retrial. The focus is on, getting justice to the commoner within a minimum time, which were across in the earlier laws have been replaced. And now we find that for women and children, special chapter has been introduced, chapter 5, wherein all the offenses related to women and children are mentioned there. Similarly, for other offenses also, now we find that all the offenses related to body are clubbed in one part, of property are clubbed in one part, so that you can just see that part and find out that whether it is an offense or not. So if I have to refer to any crime related to women and children, I will refer to chapter 5. I don't have to look for the entire Bharatiya Sakshya. It starts from the crime scene. So the crime scene, you have a forensic team who will record it, and who will see that whatever relevant evidences are there will be properly taken by the forensic team. So you have an organized people, trained people who will look into the crime scene. It's transparent. So when the procedure is transparent, even the accused knows whatever his rights are, whatever his duties are, and the victim also knows what is the procedure. So previously what used to happen in the court of law, that the victim used to keep bothering the advocate and follow up with the advocate to know the status of his case. But now it is a right of the victim to know the status of the case. Within 90 days, the status of the case will be told to the victim. A copy of the FIR will be provided to the victim, and he will know whatever the charge sheet is mentioning. Then it also consolidates the amended subsections and provisions. With time, 1860 Indian Penal Code was there, and then during the time frame, lot of sections were amended. So it was 24 ABC. Now ABC have been renamed as new laws. So it is 24, then it is 25, 26. So now you don't have subsections, but you have sections which cater to the crime. Then it also enhances the punishment in few cases, and it adds new provisions to meet the challenges of today's time. Then if I refer to section 1, it talks about what is the name of this legislation. So this legislation is called the Bharatiya Sakshya Adhiniyam 2023. It applies to all judicial proceedings in or before any court, including court-martial, but not to affidavits presented to any court or officer, nor to the proceedings before an arbitrator. So it is very clear that this act is called the Bharatiya Sakshya Adhiniyam 2023, and this applies to all judicial proceedings before any court, but it does not include, arbitrator proceedings and affidavits. Then section 2 is very important. It talks about various definitions. So I have only listed few definitions which are very important. Conclusive proof 2(1)(b) means when one fact is declared by this adhiniyam to be conclusive proof of another, the court before it, the court either believes that it does not exist, or considers it non-existent so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it does not exist. So proved and disproved have been discussed here. So whenever we are talking about conclusive proof, that means the court is considering that as an evidence. And when we say disproof, that means that the court has considered that it does not exist, or it cannot be proved. Then document has been defined in section 2D, means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures, marks, or any other means, or by more than one of those means, intended to be used or which may be used for the purpose of recording that matter, and includes electronic and digital records. So as I was just saying that technology enabled law has been made, so it also includes electronic and digital records. This has been added in the Bharatiya Sakshya Adhiniyam. So now we say that electronic and digital records are a part of evidence. A writing is a document. Words printed, lithographed, or photographed are documents. A map or plan is a document. So even if you make a plan or if you make a map, that has an evidentiary value. An inscription on a metal plate or stone is a document. A caricature is a document. An electronic record on email, server, logs, documents on computers, laptop or smartphones, messages, websites, locational evidences, and voicemail messages stored on digital devices are documents. So this law talks about adding new dimensions. So it is including law has included emails as a document. The computer logs are a document now. Messages, website, and locational evidences are also as a document. Your voicemails on digital devices are also a document. Evidence means and includes 2E all statements, including statements given by electronically which the court permits or requires to be made before it by witnesses in relation to matters or facts under inquiry, and such statements are called oral evidence. So all statements which are called oral evidence are included in the definition of evidence. All documents including electronic or digital records produced for the inspection of the court, and such documents are called documentary evidence. So now the documentary evidence are electronic and digital records. So all the electronic and digital records, what are we talking about electronic and digital records? We are talking about WhatsApp messages, we are talking about Facebook posts, we are talking about Instagram post. So everything is included in that digital record. So whenever you post on any website or whenever you like and share, you have to act reasonably. In the latest case, where a girl has posted something, retweeted something on Twitter. So it was said that you have to act reasonably. You cannot just retweet something which you do not trust or which you cannot authenticate. So I just like a post, so I should not retweet it. So you have to be digitally aware, and you have to be digitally aware sincerely. You have to work while using the digital platform, because now in the Evidence Act and in the Bharatiya Nyaya Sanhita, the digital offences are also included. So now you have to be more aware about your duties whenever you use WhatsApp, Twitter, Instagram, Facebook, or other websites. You have to act diligently. So you cannot say that I retweeted it without checking the authenticity. So whenever you post something or whenever you retweet, you have to be extra cautious. Then 2F defines fact. It means and includes anything, state of things or relation of things capable of being perceived by the senses, any mental condition of which any person is conscious. So fact has also been defined in this Bharatiya Sakshya Adhiniyam, and we have to understand that even the mental condition of which the person is conscious is also a fact. Then I will also explain you with some illustrations which are there in the Bharatiya Sakshya Adhiniyam. That there are certain objects arranged in a certain order in a certain place is a fact. That a person heard or saw something is a fact. That a person's certain words is a fact. So whenever you say something, that is a fact. Whenever you see something, or you hear something, that is a fact. When certain objects are arranged in a particular way, that is also a fact. That a person holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or what specifies time conscious of a particular sensation is a fact. So all these things are defined as fact. Then fact in issue is defined and 2G means and includes any fact from which either by itself or in connection with other facts the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessary follows. So this is also very important, that whenever we talk about in the court of law fact and issue, so facts are there. So what are the facts which are in the issue? So it includes anything which is in existence, anything which does not exist, then nature of any right, or the extent of any right, liability or disability asserted or denied in any suit or proceeding is a fact in issue. So A is accused of a murder of B. At his trial, the following facts may be in issue. That A caused B deaths. So A has caused B death. A intended to cause B death. So when I talk about intended, that means that malified intention. That A has received grave and sudden provocation from B. So if he has received grave and sudden provocation, that is in general defenses. That A at the time of doing that act which caused B death was by reason of unsoundness of mind incapable of knowing its nature. So whenever I say that that A at the time of doing the act which caused B death was by reason of unsoundness of mind. So now we are taking the defense of unsoundness of mind and incapable of knowing its nature. So he is of unsound mind and he is not able to understand that whatever his act is will result in B's death. Relevant is defined in 2K. A fact is said to be relevant to another when it is connected with the other in any of the ways referred to in the provisions of this Adhiniyam relating to the relevancy of facts. Then evidence may be given of facts in issue and relevant facts. It is very important that we cannot give evidences for unnecessary things. So either it should be related to the fact in issue or it should be related to the relevant facts. Then only the court will admit it. So section 3 talks about evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and no others. So as we discussed that relevant facts will only be having evidentiary values, otherwise you don't have to give evidences for all the things. So fact in issue is important because on fact in issue only the court will take a decision, and on relevant facts also the court will take a decision. So whenever in a court of law the argument will be based on relevant facts and fact in issue, so you have to give evidences for that only. A is tried for murder of B by beating him with a club with the intention of causing his death. At A's trial the following facts are in issue. A beating B with club, A causing B death by such beating, A's intention to cause B death. So in this illustration we find that A is tried of a murder of B and he has used club to beat that person, and the intention of causing death is also there. So what are the fact in issue? First is that A has beaten B by club. Second is that by beating him by club, A wanted to cause B's death. Third is that A had the intention of causing B's death. Then relevance of facts forming part of same transaction, section 4. This is also very important. Facts which, though not an issue, are so connected with the fact in issue or relevant fact as to form part of the same transaction, are relevant whether they occurred at the same time and place or at different times and place. I just told you that relevant facts will be discussed, then fact and issue will be discussed in any case, and some parts of facts which are related. Maybe, if that is related to that relevant fact, then this issue can also be discussed in the court of law. So what is important is, maybe I had a heated argument today, and today I have said that I will kill that person, and I killed that person 2 days after. So this is also a relevant fact because this is related. We had a fight, and then during the fight I said to that person that I will kill you. So that is also a relevant fact. So maybe that statement has been given 2 days before, but I have executed my statement even after 2 days. I have executed my statement, so that is also a relevant fact. So this is a form of part of the same transaction. Maybe I have procured certain things in 2 days to kill that person, a knife, a gun. So that is also relevant. It is also related that I have made my preparation to culminate that crime. So it is also important, and it can be also related. A is accused of a murder of B by beating him. Whatever was said and done by A or B or by bystanders at the beating or so shortly before or after it as to form part of the transaction is a relevant fact. So as I just gave you illustration, so this is also one illustration which is given in the law, that A is accused of murder of B by beating him. So whatever he has said before killing him or after killing him is also a relevant fact. A is accused of waging war against the government of India by taking part in an armed insurance in a property is destroyed, troops are attacked, and jails are broken up. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. So whenever A is accused of waging war against the government of India, and it may be a situation that he has burned the trains at a location, and in some locations he is not there, but still as he is a part of that group, so he will be charged of that offense. So it is not important that you are present at all the places. So you are waging war against the government. At some parts your people are there, and at some parts you are practically and physically participating. Maybe you are only handling the technology part. You are only posting certain you are posting certain news or posts which are irrelevant or which are creating a problem or creating law and order situation. So you cannot just retweet or on a certain post you cannot like if that is not relevant and that is not true. So if I spread something from my mobile which is not true, and maybe in a place of unrest, maybe at a place where natural situation is there, of maybe unrest situation is there, or against the government, if I start posting something, that is not done. So A sues B for libel contained in a letter forming part of a correspondence. Letters between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. So it is very important that if I write a letter to X and a part of that letter is libel, then it is not important that the entire letter has to be label. It can be whatever relevant parts are forming part of label, I will be charged for that. The question is whether certain goods ordered by B was delivered to A. The goods were delivered to several intermediate persons successfully. Each delivery is a relevant fact. So now the court of law will see that whether it is delivered at X. If it is delivered at different places, then also it will become a relevant fact. Then section 8 talks about things said or done by conspirator in reference to common design. So when people conspirate and have a common design, then every person of that group will be liable for the act. So you cannot say that I was conspiring but I was not aware that this could be the result. If you are a party to an unorganized group, or you are a party to something illegal, then you will be liable for the act of the entire group. So where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done or written by any one of such person in reference to their common intention after the time where such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring, as well as for the purpose of proving the existence of conspiracy and for the purpose of showing that any such person was a party to it. So you cannot say that I was only a party to this but I did not knew that this will also result in this activity. So I was waging war against the government but I did not knew that they will burn the trains, they will burn the buses, or they will burn the public property. So I cannot say later on because the intention was to wage war against the government. Reasonable ground exists for believing that A has joined in conspiracy to wage war against the state. The fact that B procured arms in Europe for the purpose of the conspiracy, C collected money in Kolkata and for like object, D persuaded persons to join the conspiracy in Mumbai, E published writing advocating the object in view at Agra, and F transmitted from Delhi, G at Singapore the money which C has collected at Kolkata, and the contents of the letter written by H giving an account of the conspiracy are each relevant both to prove the existence of the conspiracy and to prove A's complexity in it, although he may have been ignorant of all of them, and although the persons by whom they were done were strangers to him, and although they may have taken place before he joined the conspiracy or after he left it. So this is very important. You don't have to meet for any conspiracy. You don't have to meet. So even if you are doing online, as I just told you in this illustration, people are staying in a different location. Somebody is in Germany, somebody is in Mumbai, somebody is in Kolkata, and everybody is doing his bit. So if you are doing your bit for a common intention, you will be liable for that crime. So somebody is in Singapore, somebody is in Kolkata, but everybody is doing their bit. I may not be aware about the other portion, the other part or the other person's activity, but if I have a common intention to wage a war against the state, I am contributing factor in that, then I will be liable for the offense. Then fact showing existence of state of mind or a body or bodily feeling is defined in section 12. Fact showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will or goodwill towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or body or bodily feeling is an issue or relevant. So this can be easily proved by digital and electronic media. The first explanation is a fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists, not generally but in reference to a particular matter in question. So whatever will be the relevant fact in issue, the question will be only related to the fact in issue or relevant fact. But where upon the trial of a person accused of an offence, the previous commission of by an accused of an offence is relevant within the meaning of this section, the previous conviction of such person shall also be a relevant fact. So for habitual offenders, it is very important that if you are, again and again doing the same offence, then you are a habitual offender. For certain crimes, it is very important to understand whether that person is a first time offender or is a habitual offender. Facts bearing on questions whether act was accidental or intentional. So whenever you have to understand whether that person's act was intentional or accidental, you will be referring to section 13. When there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that such act formed part of series of a similar occurrence in each of which the person doing the act was concerned is relevant. So this is very important. A is accused of burning down his house in order to obtain money from which it is insured. The fact that A lived in several houses successively, each of which he insured is in each of which the fire occurred, and after each of which fires A received payments from a different insurance company are relevant as tending to show that the fires were not accidental. So, I had different houses. Whenever I left the house, the reason was fire. So, in a matter of case where the fact of issue is whether that fire was accidental or intentional, if I can prove that, in the successive houses also the same instance happened, and for insurance I am, putting fire in my house, then it will be a relevant fact. A is employed to receive money from the debtors of B. It is A's duty to make entries in the book showing the amount received by him. He makes an entry showing that on a particular occasion he received less than he really did receive. The question is whether this false entry was accidental or intentional. The fact that other entries made by A in the same books are also false, and that the false entry is in each case in favor of A are relevant. So, whenever somebody takes money from somebody and he tries to pay off a certain amount, then in the book of entry, the other person writes that today he had taken loan of 1000 rupees. Today he has returned 300 rupees. X has returned 200 rupees. Y has returned 100 rupees. And if in actual X has returned 400 rupees, but you are giving an entry of 300 rupees, Y has returned you 300 rupees, you are giving an entry of 200 rupees, that means that you are intentionally writing the wrong amount. So that will be a relevant fact. So if you check the book of records and then you find out that whether X, Y and other people have given 500 entry is of 400, have given 200 entries of 100 rupees, that is a relevant fact. A is accused of fraudulently delivering to B a counterfeit currency. The question is whether the delivery of a currency was accidental. The fact that soon before or soon after the delivery of B, A delivered counterfeit currency to C, D and E are relevant as showing that the delivery to B was not accidental. So, you are in a habit of giving counterfeit currency to different people. So, at one place you have given that counterfeit currency to A, and then B has also given that counterfeit currency to C, D and E. So, that is a relevant fact against A. Then confession caused by inducement, threat, coercion or promise when irrelevant in criminal proceeding. This is also very important. The term coercion is added in section 22 in the Bharatiya Sakshya Adhiniyam. So whenever we talk about confession, if it is caused by inducement, threat, coercion, promise when irrelevant in criminal proceedings. So if you use coercion, you force a person, then that confession is irrelevant. A confession made by an accused person is irrelevant in a criminal proceeding if the making of confession appears to the court to have been caused by inducement, threat, coercion, or promise having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court, and this coercion is added in Bharatiya Sakshya Adhiniyam. So, your confession has to be coming from your own self. So, if that confession is induced confession, somebody has forced you to confess, maybe that person is your owner, or that person is your employer, or that person is taking charge of you and he says that you have to confess, that is not a relevant confession. That will not be a confession under the eyes of law, because you have been forced to confess, you have been coerced to confess, you have been given threat to give that confession, or you have been promised. So that is not a confession under the court of law. To give the accused person grounds which would appear to him reasonable for supposing by making it would gain an advantage or avoid any evil or a temporal nature in reference to the proceeding against him, provided that if in that confession is made after the impression caused by any such inducement, threat, coercion, or promise has, in the opinion of the court, has been fully removed, it is relevant. So if you think that, if you force a person and you say that, you give a threat to that person that your family is my responsibility, and if you do not confess, then that family will suffer. Maybe, that family will not be able to sustain. And if the person confesses, then that was not a confession under the eyes. But if the court is able to understand that, okay, this confession was there because of threat, but there are evidentiary value to this confession because the circumstances or the facts of the case suggest that you have given a confession of that crime which you did. Confession was of that crime which you did. It is not that somebody has, forced upon you that you confess for a crime which you have not done. So that part will be relevant for the court. Then confession to a police officer is section 23. No confession made to a police officer shall be proved as against a person accused of any offence. No confession made by any person while he is in custody of a police officer, unless it is made in the immediate presence of the magistrate, shall be proved against him. A very important point, because if you are in the custody and then you confess, that confession is not valid unless you give it before the magistrate. Provided that when any fact is disposed to and discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as related distinctly to the fact discovered, may be proved. But if you confess in the custody and then certain things or certain arms, or maybe that person has confessed before the police officer, and after his confession, the police officer goes for the raid and he finds the arm or ammunition which has been used in that crime, that has an evidentiary value. So whatever you made before the police officer, your statement is not relevant, will not be a confession. But after that confession, if the police officer has, taken out some evidence, maybe the arms, or maybe that substance, or maybe, the money, or in a case of theft, the valuable things have been recovered, or maybe, the clothes of that person has been recovered, then that will have an evidentiary value. Consideration of proof confession affecting persons making it and others jointly under trial for the same offense. This is also very important, as I just said, that section 24 talks about this. When more persons than one are being tried jointly for the same offense, and on confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. So in a joint trial, whenever you are a person in group and you commit crime in a group, then if you confess for your crime, then this confession can also be proved for the other people of the same group. So because if you confess, you will also tell the things which you have used for that crime. Then you will also tell the entire procedure, or maybe your plan. You will disclose the plan, so that will have evidentiary value and will act also against the other people in that same group. So when you are jointly tried, then your confession can also be proved against other people in that group. Relevancy of certain evidence for proving in subsequent proceedings truth of facts therein stated. This is also a very important, section 27. Evidence given by a witness in a judicial proceeding or before any person authorized by the law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in the later stage of the same judicial proceeding the truth of the facts which it states. When the witness is dead or cannot be found, or is incapable of giving evidence, or is kept out of the way by the adverse party, or if his presence cannot be obtained without an amount of delay or expense, which under the circumstances of the case the court considers unreasonable. So your evidence can also be used in the subsequent proceeding, or in the same proceeding at a different pace. So when the witnesses are dead or cannot be found, or the person is not able to give evidence, or he is kept away by the adverse party, or his he is somewhere from where maybe in a foreign land, so it is very difficult to bring that person for a witness. So in these circumstances the court can consider the witness, provided that the proceedings was between the same parties or their representatives in the interest, and the adverse party in the first proceeding had the right and opportunity to cross-examine, and the questions and issue were substantially the same in the first as in the second proceeding. So it has to be a related proceeding, and the first party should always be given, the adverse party should always be given the right to cross-examination at the first instance. Fraud or collusion in obtaining judgment or incompetency of court may be proved. This is also very important. Any party to the suit or other proceeding may show that any judgment, order or decree which is relevant under section 34, 35 or 36 and which has been proved by the adverse party was delivered by a court not competent to deliver it, or was obtained by fraud or collusion can be proved. Then opinion of expert is very important. This has been added in Bharatiya Sakshya Adhiniyam, section 39. When the court has to form an opinion upon a point of foreign law or of science or any art or any other field, or as to identity or handwriting or finger impression, the opinion upon that point of person specially skilled in such foreign law, science or art or any other field, or in question as to identity of handwriting or finger impression are relevant facts, and such persons are called experts. So as I just discussed that in Bharatiya Sakshya Adhiniyam, the opinion of experts can be taken now. So whenever you are referring to people, you will always talk about expert opinion. So I may sitting at a position of judge, the judge is empowered to have an expert opinion, so he can tell that here I want some medical people who will be giving their opinion. Here I want the forensic team. So at the crime scene, when the forensic team visits and it records the statements, it takes all the evidences, it is very easy for the judge to understand that these are the relevant evidences. So at any point of time, if the judge wants that, he has to contact those people who had taken that evidence, then judge can always fall back upon. Even for scientific evidences, even for fingerprint, you can call an expert. And then section 47 talks about, in criminal proceedings, the fact that the person accused is of a good character is relevant. It is very important that this will differentiate between habitual offender and first time offender. So it is very important that now we are taking up crime not as a stigma, but for habitual offenders the laws are stringent. Even the punishment is stringent. Then section 49 talks about, in criminal proceedings, the fact that the accused person had a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. Then electronic or digital records are there in section 61. Nothing in this Adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is electronic or digital record, and such records shall, subject to section 63, have the same legal effect, validity and enforceability as other documents. So now the digital records, the electronic records have the same validity as the other records. So it is very important that we have to understand that whenever we write a post, we send a message, we have to be conscious. Then public and private documents are there in section 74. The following documents are public documents: documents forming the acts or records of the acts of sovereign authority, of official bodies or tribunals, of public offices, legislative, judiciary and executive of India or of a foreign country. Public record kept in any state or union territory of private documents. All other documents except the documents referred to in subsection 1 are private. Then presumption as to gadgets in electronic or digital record. This is very important. Section 81. The court shall presume the genuineness of any electronic or digital record purporting to be the official gadget or purporting to be electronic or digital record directly by any law to be kept by any person if such electronic or digital record is kept substantially in the form required by law and is produced from proper custody. So tampering of evidences has to be checked. So you have to maintain, it is the duty of the government servant to ensure that the records are kept properly, and reasonable care and cautious has been taken by that person while keeping the digital and electronic records. So you have to keep the digital and electronic record properly. You have to maintain the secrecy and maintain the that the records are not tampered with, the records are not done away, or the records are not manipulated. So this is the duty of that government officer. For the purpose of this section and section 93, electronic records are said to be in the proper custody if they are in the place which are looked after by the person with whom such document is required to be kept. But no custody is improper if it is proved to have had a legitimate origin, or the circumstances of that particular case are such as to render that origin probable. So it is very important that electronic record has to be maintained and kept in safe custody by the officials. Presumption as to electronic messages, section 90. The court may presume that an electronic message forwarded by the originator, though an electronic mail server to the addressee to whom the message purports to be addressed, corresponds with the message as fed into his computer for transmission, but the court shall not make any presumption as to the person for whom such message was sent. So this is very important. Whenever you write a message, then the server will be checked, and every server will tell the details of the time, the person for the sender and the receiver of that message. It is very important that whenever you record these evidences, in the court of law, then you have to be properly, you have to act diligently. You have to be sure that the records are not tampered at any place, because we have a team who looks after whether the records are tampered or not. Then professional communication is section 132. No advocate shall at any time be permitted, unless with his client express consent, to disclose any communication made to him in the course and for the purpose of his services as such advocate by on behalf of the client, or to state the contents of the condition of any document with which he has become acquainted in the course and for the purposes of his professional service, or to disclose any advice given by him to his client in the course and for the purpose of such service. This is also very important, section 132. So just to have some more clients, just to have, a media bite, you have to be very conscious that, you cannot disclose about your client's case. You cannot give some statements in the media or on the social platforms when the case is before the court of law. So advocate has to be conscious about his duties. Then a very important section 170, because a lot of people had this apprehension in mind that okay, the new laws have come into force from 1st of July 2024, but suppose any crime has happened before that, so whether the new laws will be applicable or whether the old laws will be applicable in that case. So section 170 talks about that. The Indian Evidence Act 1872 is hereby repealed. So we find that some laws are repealed. That means that law is no more in existence. Some laws are amended. So the law is in existence, but certain provisions are amended. Here, the Indian Evidence Act is repealed now. Notwithstanding such repeal, if immediately before the date on which the Adhiniyam comes into force, that is 1st July 2024, there is an application, trial, inquiry, investigation, proceeding or appeal pending, then such application, trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provisions of Indian Evidence Act 1872 as in force immediately before such commencement as if this Adhiniyam has not come into force. So a very important section which clearly tells you that if any offence has been committed before 1st of July 2024, then Indian Evidence Act will be applicable. But the digital and electronic and the new technology which has been used by the lawmakers will definitely be included in these cases also. But for the cases or for the crimes which have been committed on 1st of July 2024, the sections of the Bharatiya Sakshya will be applicable. For evidence, Bharatiya Sakshya Adhiniyam will be applicable. And for procedure, Bharatiya Suraksha Sanhita will be applicable. So if the crime has occurred before 1st of July 2024, then the old laws will be applicable. But for having a holistic view, this digital record can always be included for the old laws also, because the technology driven society, we are using technology even for charge framing, because it is very easy to understand that if you record the crime scene, previously it was not mandatory that every crime scene should be recorded or forensic team should visit. but now the states are required to have their forensic teams. So every state has to ensure that they have the forensic teams well in place, and whenever a crime happens, the forensic team has to go there and record the evidences. So even for, it was there previously also, that in camera proceedings were there previously also, but with the advent of technology, now you don't have to go to give your statement in the court of law. You can sit here in the studio and you can record your evidence. So by recording evidence at my location, I am safe. Nobody will even come to know that, okay, I have given evidence at this point of time and my evidence will be recorded. So it is not there, even for the victim, it is very easy that if once my statement is recorded, everywhere that statement can be used. I will not recreate that same impression or recreate the same incident. Whenever I say or whenever I make a statement, I will have to go through that same pain again and again. But by this evidence recording, I can just record my statement and give it at all platforms, and everybody can listen to it, everybody can see it. So it is witness centric, it is, victim centric. We have witness protection schemes, but with the advent of technology, by the use of technology, with the use of, expert opinion, I can understand. And it is very important that you have to understand that, whenever you make a statement on the social media platforms, even when you send an email to any person, you have to be reasonable enough to write an email. You should know what to write and what not to write. So Bharatiya Sakshya Adhiniyam is there in place from 1st July 2024, and you have to be vigilant enough. And now justice delayed is justice denied. It is a right statement. So with the advent of technology, we are hoping that, the conviction rates will increase and people will get justice within time frames. And everybody, will have faith in the judicial system also, because it is transparent now. So we have a transparent system where everything is being recorded, where the victim also knows that this is the statement, this is the recording, and this is the status of my case. So we have a better law, and we have a better law for the commoners, because commoners are not able to understand the legal term. But now it is the duty to tell you about the case situation and the case status. So you will know your rights, you will know your law, you will know your situation, and then you will be able to get justice. Thank you all for listening. Have a great day.
We wear clothes on a daily basis. But have we ever wondered, where do our clothes come from? Who makes our clothing? And who are the people and the process responsible for the whole manufacturing of our clothing? If you want to know more about this, Indira Gandhi National Open University from the School of Continuing Education has launched a program which is Certificate in Apparel Merchandising. There are many benefits after doing this program. You can become a designer in various fields. It can be fashion designer, apparel designer, costume designer, or even a textile designer. One can also work as a fashion consultant. Research and development is another field which one can take up after doing this certificate course. Going into academics is another perk after doing this program. Getting into fashion houses or fashion studios as an intern is also a very good option post doing the certificate in apparel merchandising. The basic eligibility of the program is 10+2. The duration of the program is 6 months to 2 years. The program is also available for both the admission cycles, which is July and January. The exams are conducted twice a year. in June and December. So what are you waiting for? Join this program and get an enriching knowledge in the field of apparel merchandising. And to do so, you can log on to the official website of the university, www.ignou.ac.in.
Hello learners, I am Professor Munish Kumar Bharadwaj from School of Engineering and Technology of IGNOU and today I'll discuss with you on the course Safety in Construction, which is MIS 023 in your first semester curriculum. So this course actually is covered in two blocks. First block is safety during construction and second block is about prevention of accidents in construction. What are these blocks basically? These are the booklets and each block is generally having 4 units, means generally what we call as chapters. We call these here as units. So these are the two blocks basically. Each block is having 4 units. What are these 4 units? Let us see. In block 1, there are 4 units which are unit 1 talks about the general safety in construction. Unit 2 talks about safety aspects in underground works. Then unit 3 talks about safety in works at height, whereas unit 4 covers the safe handling of construction machinery and materials. This is all about the block 1. Then in block 2, what we cover is unit 5 talks about the environmental safety. Then unit 6 talks about safety during demolition operations. Then unit 7 talks about training and development of construction workers. And finally, in unit 8, you will see the case studies on construction safety, in which you will see different case studies of different type of accidents which occurred in the past in the construction industry. So these are the 4 units which are covered under the 2 blocks basically. So this makes the whole course of the safety in construction, which is MIS 023. So let us begin with why safety. You must be seeing such type of news. You must be coming across such type of news every second day, third day. As you see here that some workers die at a construction site. There are problems with the environmental pollution at the construction site, and the companies fined for that pollution causing to the environment basically. So these are the things basically which are naturally associated with the construction industry. If I talk a rough estimate, around conservatively if I talk, then around 11,000 accidents are there every year which are fatal accidents in construction industry. And if I compare this with all the fatal accidents that are occurring every year in India in all type of industries, then construction industry has a share of 25% of the total fatal accidents. Means roughly around 45,000 accidents are happening in the various industries in India, out of which around 11,000 are only in construction industry. So that is a very big problem basically, and this is the reason why we should worry about safety aspects in construction industry. Then if I talk about that very nature of the construction industry, here in India, basically construction industry, as I told you, has a very dubious record regarding the safety. Because by its nature also there is a problem. It is